Hey there, I'm estate planning attorney Paul Rabelais, and in this video I'm going to describe several probate avoidance tools that people use in estate planning. But before we jump into the weeds, let's first go over what probate is and why someone would want to avoid it. Probate is the court-involved and attorney-involved process of taking frozen assets that are titled in the name of a deceased individual and transferring ownership of those assets to their rightful heirs. For example, let's say you pass away with 3 assets that are solely in your name: a home, a car, and a bank account. Well, the moment you pass away, those assets are frozen. No one can sell the house or put it in their name. No one can sell your car or put it in their name. And no one can access the funds in your bank account. Even if you have a last will and testament, which clearly dictates who is entitled to inherit those assets, nothing can be done until a probate proceeding is initiated. Now, there are exceptions to that statement, particularly if some of the tools described in this video are utilized. But generally, if you have assets in your name when you die, your heirs must go through probate. What people don't like about probate is that it can be expensive and it can take a long time. Lawyers, like myself, must be hired. I've been involved in more than 1,000 probates. Lawyers must prepare various sets of court pleadings, inventories of assets, court orders that get submitted to a judge. And these lawyers and the probate participants must follow a very particular set of probate rules that each state says must be followed. And note that this can be a stressful time because the heirs are sharing a pool of money. And often these heirs do not know exactly what that pool of assets consists of. So they are at the mercy of lawyers, executors, other heirs, judges, courthouse employees, and financial institution employees, many of who either the heirs do not know or trust, or the heirs believe these people are incompetent. So, setting up an estate to avoid probate and allow assets to pass quickly and easily to heirs is big business. The following are several tools that estate planning attorneys, financial planners, and their clients use to enable their survivors to avoid the court and attorney-involved probate process. So the cornerstone of most avoid probate estate plans is the revocable living trust. The general idea behind a revocable living trust is that assets titled in your name when you pass away are frozen, and you must hire lawyers, go through probate, and get judges involved in a court proceeding in order to gain access to or transfer those assets to heirs. However, assets in your typical revocable living trust are not frozen when you pass away. In your trust instrument, you designate a successor trustee of your trust. You are the initial trustee during your lifetime. And that successor trustee handles your trust when you die. And this successor trustee can distribute the trust assets to the trust beneficiaries as you designated in the trust instrument. One of the benefits of having a revocable living trust in place is that while the assets in your trust will avoid the court and attorney-involved probate proceeding, your revocable living trust can also include one or more subtrusts that take effect when you pass away. These subtrusts are commonly used when you might have a minor or young beneficiary, or when you just do not want to dump a lump sum inheritance into the hands of one or more beneficiaries. I'll come back to these subtrusts when I discuss some of the other probate avoidance tools. So a second way to enable heirs to avoid probate when you pass away is to designate beneficiaries on all of your retirement accounts. If a father, for example, designates his 2 children as 50-50 beneficiaries on his 401k, his traditional IRA, and his Roth IRA, then when the father passes away, the children merely need to produce their father's death certificate to gain access to these funds. Note, however, that if the father names his estate as the beneficiary, or if the father neglects to designate beneficiaries and the plan requires that his account be payable to his estate in the event no beneficiaries are designated, then those accounts will be part of the probate estate, requiring more red tape, legal dealings, and delay. Another similar way to avoid probate for your life insurance and annuities is to designate beneficiaries. Like retirement accounts, those policies are payable to whomever you designate as the beneficiary on the insurance company's beneficiary designation form. And note that if you do have a revocable living trust that creates subtrusts for beneficiaries after you pass away, you could designate your revocable living trust or one or more of these subtrusts as the beneficiary of some or all of your life insurance. This is a no-brainer, for example, if you have life insurance to cover the expenses of your minor children if you pass away. You don't want life insurance proceeds, or any inheritance for that matter, payable to a minor. This can require another court, guardianship, or conservatorship proceeding. You'll want anything that might be for the benefit of a minor to be payable to a trust for the benefit of the minor to keep those assets from being subject to judicial supervision. Now, another way to avoid probate regarding certain investment accounts or even real estate is to title the property or the account joint tenants with rights of survivorship. Joint tenants with rights of survivorship is most commonly used by married couples who want to jointly own an asset and provide that when one joint tenant or one spouse dies, ownership automatically goes in full to the surviving joint tenant. Property held in a joint tenant with rights of survivorship arrangement avoids probate when the first joint tenant dies. The last living owner owns the asset. The disadvantages of joint tenants with rights of survivorship are: first, a joint tenant cannot pass their ownership interest to their heirs. Second, the first joint tenant to die has no say-so where the assets go when the surviving joint tenant dies. The surviving joint tenant gets to control the disposition of the asset. And third, if both joint tenants pass away together or within a short period of time of each other, the asset must go through probate because the asset will be part of the probate estate of the surviving joint tenant. Another way to avoid probate regarding your bank or credit union accounts is to set up a payable on death or POD arrangement. Many banks or credit unions will allow you to sign the POD forms. Just like it indicates, when you set up a POD account at a bank and then you pass away, your bank will pay the account balance to your POD beneficiaries outside of probate. Some of the downsides of a POD account are: first, you often cannot name contingent beneficiaries like you can in a will or living trust. So if you set up a POD account and a POD beneficiary predeceases you, the funds may not go how you want when you pass away. Second, if you set up a POD account and then become incapacitated, no one will be able to access those funds on your behalf unless you've created a durable power of attorney and the bank or credit union accepts that power of attorney. Some people opt to put their bank account and credit union accounts in their revocable living trust, and in the revocable living trust instrument, it addresses how the successor trustee can access trust assets upon your death or incapacity, and who those assets should be distributed to when you pass away, including what happens if a beneficiary predeceases you. And yet another way to avoid probate regarding investment accounts that are not retirement accounts that I addressed above is to set it up as a TOD or transfer on death account. A TOD investment account at a brokerage firm like Fidelity or Schwab is similar to a POD account at a bank or credit union. The TOD account automatically transfers to one or more named beneficiaries when the account owner dies. TOD accounts potentially have the same pitfalls of a POD account. You can't name contingent beneficiaries, guardianship proceedings are likely necessary if you die and a minor is a TOD beneficiary, and no one can access the TOD account during your lifetime, during your incapacity, unless your durable power of attorney takes care of that. So if you have a revocable living trust, it may be better to make your investment account a revocable living trust account, where all these pitfalls can be managed by the terms in your revocable living trust instrument. And a final hack to avoid probate is simply to give away or donate assets to your heirs before you die. Maybe you're thinking you'd rather go ahead and put that vehicle or that lot or that piece of rental property or that stock in the name of your heir or heirs before you die so that they don't have to go through the trouble of probate to have it put in their name after you die. But before you start giving away all of your assets for probate avoidance purposes, be well aware that you will lose control of those assets after you give them away, and those assets will not benefit from the step-up in basis that heirs enjoy when they inherit appreciated assets at the time of your death. So there you have it. Typically, avoiding probate involves setting up your revocable living trust the right way, and then optionally using different methods to title assets either in your trust name or with another method that avoids probate, and then also naming either individuals, your revocable living trust, or one or more subtrusts described in your revocable living trust as a beneficiary of certain accounts or assets. And know that laws governing estate planning can and do vary by state. Hope that helps. Have a great day.